A few days before Thanksgiving this year, the estate of Johnny Cash, the man in black, filed a lawsuit against Coca-Cola, alleging that Coke used the Johnny Cash Soundalike singer in its nationwide Fan Work is Thirsty Work college football ad campaign, and did so without permission. The complaint claims violation of Tennessee's new Elvis Act and the Lanham Act's false endorsement provision. I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and I'm joined today by my partner, Richard Buckley. We are going to talk about the Cash Estates lawsuit and cover the state of the law on soundalikes on today's installment of the briefing. Richard, welcome back to the briefing.
Thank you, Scott. Great to be here as always.
Yeah, good to have you back. So this one, I think this one's an interesting one. So let's set the stage. On November 25th of this year, the Johnny Cash Trust filed a complaint in the Middle District of Tennessee against the Coca-Cola Company. According to the complaint, Coke launched a national TV and digital ad titled Fan Work is Thirsty Work in August of this year, right at the start of the NCAA football season. The ad featured fans drinking Coke and Coke Zero while a male voice sings over the visuals. So here's a brief clip. I stand alone with fire inside, with passion burning in my veins. That male singing voice, at least according to the complaint, sounds remarkably like Johnny Cash. The estate alleges that Coke hired a Johnny Cash tribute singer, someone who markets himself as the #1 Johnny Cash tribute show, specifically so the commercial would sound like Cash without ever seeking permission or a license. The complaint even includes screenshots of social media comments where viewers say they believe the ad used Johnny Cash's actual voice.
And I noticed that the estate claims it didn't even know about the ad until November 14, months after the ad launched.
Right, right. And by that time, Coke had already been running the commercial throughout the season across NBC, ABC, ESPN, and Fox, and across social platforms. The complaint alleges that Coke often enters into paid celebrity endorsement deals, including past deals with musicians. So Coke supposedly knew that a license would be required or normally required.
Another interesting fact, the complaint references a Facebook post dated August 30, 2025, in which the Soundalike singer promoted the ad and included the hashtags Johnny Cash and Man in Black.
Right. All right, so let's dive into the Elvis Act. So one of the claims in the complaint is a violation of the relatively new Elvis Act, which is Tennessee's Ensuring Likeness, Voice, and Image Security Act of 2024. Gotta love those acronyms. This is something we already covered on this podcast, but we'll do a kind of a brief recap here. So the Elvis Act amended Tennessee's right of publicity statute to explicitly recognize voice, including simulated or imitated voice, as a protected property right. The statute defines voice as follows, quote, a sound in a medium that is readily identifiable and attributable to a particular individual, regardless of whether the sound contains the actual voice or a simulation. That language, quote, regardless of whether the sound is a simulation, is tailor-made for sound-alike scenarios.
It is. The statute also creates liability not just for using the voice, but also for publishing, distributing, or transmitting an unauthorized voice.
Exactly. And Coke is accused of doing both, using a Cash sound-alike to advertise its product and widely broadcast that ad. The statute allows for recovery of actual damages, attributable profits, and even punitive damages if the violation is willful. And as one would expect, the trust alleges Coke acted knowingly and willfully.
One of the requirements of the Elvis Act is that in order for an action to lie, the voice must be quote, readily identifiable and attributable to a particular individual, end quote. This is a relatively new statute, and I understand that there really hasn't been any judicial determination of what it means for a voice to be readily identifiable and attributable to a particular individual. Assuming that Coke doesn't settle, I imagine that Coke will argue that the voice in the ad was not readily identifiable and attributable to Johnny Cash. Scott, what do you think of that argument?
Yeah, I mean, yes, I think Coke, if it doesn't settle, is going to raise that, and that has to do with the style versus voice imitation that we're going to talk about a little bit later when we talk about weights versus Frito-Lay. Because I think it's all kind of wraps together. But I agree, that's going to be a major question that this case will have to answer. Given that the Ninth Circuit has what really are the leading cases involving soundalikes, I assume that the court may look to those cases for guidance.
Well, that's a good segue for us to look at California's right of publicity framework and the two key sound-alike cases, Midler versus Ford and Waits versus Frito-Lay. California Civil Code Section 3344 prohibits the unauthorized commercial use of a person's name, voice, photograph, or likeness. But Section 3344 applies only when the actual voice is used. Under the California common law standard, a plaintiff must show four things. A, the defendant appropriated the plaintiff's identity. B, there was an advantage to the defendant. C, a lack of consent. And D, resulting injury.
Right. 3344 and Tennessee's right of publicity statute were really very similar prior to Tennessee's amendment and the enactment of the Elvis Act. And really, the enactment of the Elvis Act was like a direct reaction to a lot of these fake AI uh, songs that were coming out that were imitations and replications of well-known artists, but obviously they were not using the actual voices because the output was AI generated, and so California has yet to amend its or revise its right of publicity statute 3344 to address this, but I imagine that they probably will, given that California is on the cutting edge of this. They were one of the first states to amend their right of publicity framework to allow for deceased celebrities or the estate of deceased celebrities more accurately to claim violations of right of publicity. So I assume that this is probably already in the works. But why don't we get into the key sound alike cases? And 'cause I think, as you said, the court in this case is probably going to look to these cases, or at least I think they're going to look to these cases for guidance. So let's take a look at the 1988 Ninth Circuit decision in Midler versus Ford. This is truly a seminal decision that established for the first time that a celebrity's distinctive voice can be protected as an element of their identity under California's common law right of publicity, even when the advertiser uses an imitator, not the actual voice of the celebrity.
So here's the background. In the mid 1980s, Ford Motor Company and its agency, Young and Rubicam, launched the Yuppie campaign. It's a series of ads designed to evoke nostalgia by featuring well-known songs from the 1970s. The agency wanted the original people who made the songs famous to re-record their hits for the commercials. In cases where they couldn't get the original artist, they used sound-alike singers. For the commercial at issue, Y&R wanted Bette Midler to sing her hit, Do You Want to Dance? Which, by the way, I heard for the first time today, and it's a great song. When they contacted Ms. Midler's manager and disclosed it was a commercial, Midler conveyed that she was not interested.
Right. So rather than changing the plan, Y&R used Ulla Hedwig, who had been a backup singer for Midler for 10 years. Hedwig was told the agency wanted someone who could sound like Bette Midler's recording and was instructed to imitate Midler's 1973 performance as much as possible, with only minor modifications. After the ad aired, both Midler and Hedwig received comments from numerous people who believed Midler herself was the singer.
Midler sued Ford and its ad agency, alleging they had appropriated her voice, an inherent part of her identity, for commercial gain. The district court granted summary judgment for the defendants, holding that imitation of a voice was not actionable. The Ninth Circuit reversed.
Let's take a little detour here and let's talk about why the copyright law didn't bar Midler's claim. The defendants in this case, Ford Motor Company and the advertising agency, had licensed the musical composition legitimately. So copyright law didn't protect Midler's voice because a voice isn't a copyrightable work of authorship, and mere imitation of a sound recording is expressly permitted under Section 114B of the Copyright Act. The Ninth Circuit emphasized that Midler was not claiming infringement of the recording, but rather appropriation of a personal identity attribute.
And let's take a sub detour and talk about Section 114B of the Copyright Act.
We'll continue on the detour here.
Scott, you discussed that provision on the episode where you covered whether the fake Drake AI generated song was actionable.
Right. So, okay, as noted, Section 114B permits soundalikes. A publication by the U.S. Copyright Office specifically says that, quote, under U.S. copyright law, the exclusive rights in sound recordings do not extend to making independently recorded sound-alike recordings. Copyright protection for sound recordings extend only to the particular sounds of which the recording consists and will not prevent a separate recording of another performance in which those sounds are imitated. The imitation of a recorded performance, no matter how similar to the original the imitation may sound, would not and do not constitute a copyright infringement, even where one performer deliberately and intentionally sets out to simulate another performance as exactly as possible.
And this probably explains why the Cash estate didn't bring a copyright claim, because his voice is not copyrightable. It also may explain why Coke will not be able to rely on the Copyright Act as a defense, because the use of Cash's voice, his personal identity attribute, is a separate act that stands separate and apart from the rights protected by the Copyright Act.
Right, I agree. All right. So getting us off the detour and back on track here and getting back to Midler, it's important to understand why California's statutory right of publicity didn't apply. So California Civil Code Section 3344 protects against the use of a person's name, voice, signature, photograph, or likeness, but that statute only applies where the defendant uses the actual thing, for example, the actual voice. Because the commercial used a sound-alike voice and not Midler's actual voice, the statute didn't apply. However, the court noted that 3344 is cumulative and does not eliminate, lucky for Midler, the common law tort of appropriation of identity.
In an appeal from the district court's dismissal, the Ninth Circuit held that Midler had a valid common law claim for appropriation of identity. In doing so, the court made several foundational statements that continue to shape sound-alike law. One, a voice is as distinctive and personal as a face. Another example, the human voice is one of the most palpable ways identity is manifested. Court also noted to impersonate her voice is to pirate her identity. The court emphasized that the defendant's intent was clear. They tried to hire Midler, were refused, then, quote, acquired the services of a soundalike, end quote, and instructed her to imitate Midler's voice. The court found that Ford sought to appropriate an attribute of Midler's identity, something of commercial value, without paying for it.
Right. The summary of the Midler case is basically the following. When a distinctive voice of a professional singer is widely known and is deliberately imitated in order to sell a product, the sellers have appropriated what is not theirs and have committed a tort in California.
Waits versus Frito-Lay is the second major Ninth Circuit case after Midler. to hold that using a deliberate sound-alike to impersonate a celebrity's distinctive voice in an advertisement violates the common law right of publicity. It's also the case where the plaintiff, Tom Waits, actually went to trial and won. In 1988, Frito-Lay and its ad agency launched a campaign for Doritos chips. The creative team wanted a voice that captured the gravelly, unmistakable sound of singer Tom Waits, whose raspy, idiosyncratic vocal style is instantly recognizable.
So unlike the Bette Midler, who had simply declined to do the commercial, Waits had a long public history of refusing to do ads. Despite this, Frito-Lay's ad agency hired a sound-alike vocalist, and they told that vocalist they wanted a voice, quote, in the style of Tom Waits. The resulting commercial featured the sound-alike singer speaking in a raspy, gravelly impersonation of Waits, layered over music that echoed Waits' style.
So, of course, Waits sued essentially for voice misappropriation under California state law as a violation of his common law right of publicity and false endorsement under the Lanham Act. Unlike Midler, which went up on summary judgment, Waits went to trial. The jury awarded Waits approximately 2.6 million in both compensatory and punitive damages.
And that was a fairly large right of publicity verdict at that time. And one would think a very clear cautionary tale for advertisers, right?
Oh, indeed. And on appeal, the Ninth Circuit affirmed almost every aspect of the verdict. The court reiterated and strengthened the rule from Midler. A deliberate imitation of a widely recognized, distinctive voice for commercial purposes is a misappropriation of the celebrity's identity. The court emphasized Waits' raspy voice was unquestionably distinctive. Frito-Lay's imitation was intentional, not incidental. Consumers were deceived. Actual confusion occurred. And the ad suggested that Waits had endorsed a product he had never endorsed.
The court discusses the difference between imitating a protectable voice and imitating a non-protectable style. As we talked previously, I think, and I think you think, this is going to be relevant in the Cash case. And I suspect Coke is going to argue that it only intended to imitate Johnny Cash's style.
At trial, in the Waits case, the defendants proposed jury instructions which distinguish in detail between voice, which is protected under Midler, and style, which is not. The court rejected those instructions and instead gave jury instructions on voice misappropriation that tracked closely the elements of the tort as they are formulated in Midler. The court's instruction directed the jury to decide whether Waits' voice is distinctive, whether his voice is widely known, and whether the defendants had deliberately imitated his voice. On appeal, the defendants argued that their proposed style instruction was crucial, but the Ninth Circuit found that the jury instructions given were not misleading. The court also affirmed Waits' Lanham Act false endorsement claim, holding that a celebrity's voice can function like a trademark, a symbol of identity or personal brand whose unauthorized use can mislead consumers.
So, as we mentioned at the beginning, the trust also brought a claim under the Lanham Act for false endorsement. And this false endorsement claim is essentially a misappropriation claim. The defendant's use of a celebrity's identity in a way that is likely to cause consumers to believe that the celebrity endorsed the product. Here, the Cash estate argues that Johnny Cash's voice functions as a source identifier, as the court found in Waits, like a trademark, and that the imitation misleads consumers into believing the Cash estate approved or endorsed the use of the Cash voice in the Coca-Cola ad.
And the complaint actually includes evidence of actual confusion. Social media comments showing viewers believe the ad used Cash's real voice.
Yeah, that's going to be powerful evidence. False endorsement claims don't require actual confusion, but when it exists, courts are going to give that substantial weight. All right. So if this case doesn't settle immediately, let's talk about what defenses Coca-Cola might raise.
There was some discussion in the Waits case that may require some exploration here. The Ninth Circuit noted that the trial's focus was on the elements of voice misappropriation as formulated in Midler, whether the defendants had deliberately imitated Waits's voice rather than simply his style, and whether Waits' voice was sufficiently distinctive and widely known to give him a protectable right in its use. So the approach that Coke may take is that the intent was not to imitate Cash's voice, but rather his style.
Right. Or that um, Cash's voice was not sufficiently distinctive. But I don't know that that one's going to be, I don't know that that one's going to fly. So, assuming that the court follows the formula from Waits in determining whether the voice or the style was imitated, so they'll look at, was Cash's voice distinctive? Is his voice widely known? And did the defendants deliberately imitate his voice? I don't know that that defense will be a winner. Um, right? And then there are the posts from the Soundalike artists that included those hashtags, which tend to indicate deliberate imitation by Coca-Cola.
I imagine there might be some problem trying to get that into evidence, at least as to Coke's intent. Um, that's not a statement that can be attributed to Coke unless Coke specifically told the Soundalike singer that they were trying to imitate Cash's voice. Um, if it doesn't settle, then there will probably be significant discovery around Coke's intent in hiring that specific singer.
Right. No, I agree. I agree. I think Coke could also argue no likelihood of confusion that consumers weren't confused. I mean, Johnny Cash is dead after all. Um, but based on the comments included in the complaint, that may be a challenge.
Coke will probably also argue that the voices are not sufficiently similar. Um, this goes back to the style versus voice issue, but again, they used a professional Cash tribute artist, someone whose job it is to sound exactly like Johnny Cash.
Right, right. Um, I mean, Coke may try to make a First Amendment argument, but that would be a really weak one because the ad is purely commercial speech.
Coke may also try to argue preemption under the Copyright Act. A right of publicity claim can be preempted by the Copyright Act, but it depends on the specific facts of the case. If the claim is based on the use of a person's identity in a way that is directly equivalent to the use of a copyrighted work, kind of like using a photo or audio clip from a movie, it's more likely to be preempted. However, claims are less likely to be preempted if the identity is used independently of a copyrighted work, such as when a person's likeness is used to endorse a separate product.
Right. Let's also not forget that this is a pretty new statutory provision. So it'll be interesting to see what other holes Coke may try to poke in the Elvis Act. But I want to talk about this. So, Waits and Midler are well established. There was significant coverage over the enactment of the Elvis Act. Coca-Cola does not lack for resources, and I'm sure has many, many, many lawyers on staff. So, how, Richard, do you think this happened?
Yeah, it's difficult to say. I think that if you assume that everything that Coca-Cola does is reasoned and deliberate and researched and intentional, then perhaps they um, put a lot of weight into this style argument and the fact that in the commercial, it's not a Johnny Cash song, it's an original song.
Right.
And so potentially they could argue that by definition, we have um, content that is in the style of Johnny Cash. And maybe they just hyper focused on that. But that would also assume that they didn't necessarily weigh the jury instructions in the Waits case.
Right. I mean, taking into account Midler, right? The fact that it's an original song and the fact that the composition was licensed are kind of the same thing, right? Because it means that they have the right to record those particular um, lyrics. So we're just dealing with the sound of the voice itself. Um, I mean, I have to think that if Coca-Cola is launching a national ad campaign, not only are their lawyers going to take a look at that, but the lawyers of the ad agency, which I assume is humongous as well and does not lack for resources or lawyers, Um, they have to they have to be relying on the argument that it's style versus imitation. I mean, when we played the clip, it kind of sounds like Cash, but I must say, when I played the clip, I didn't immediately listen to a Johnny Cash um, sound recording. But I'm gonna say this: I don't think it sounds exactly like Johnny Cash.
No, it sounds like arguably a country singer with a deep voice, and of which there are many.
Right.
And it's somewhat generational too. You know, Johnny Cash is familiar to me and probably to you, but I'm not sure he's so familiar to for example, my son and my daughter. Um, who knows?
I mean, I think this is going to be, if it doesn't settle, it's going to be a very expensive case because they're going to get musicologists and they're going to get voice experts, and there's going to be a battle of the experts over whether or not this really is an imitation of voice or an imitation of style. Because I think anybody, look, anybody has the right to be a gravelly voiced singer in a deep octave. When does that cross into infringing Cash's identity? I guess is when it sounds more like Johnny Cash than it doesn't.
And when you hire a professional Johnny Cash imitator, that's not a great fact if you're Coca-Cola.
No, I mean it's not a great fact, but it might be that it's very hard to obtain that sound, right? That gravelly kind of deep um, sound. So maybe that's the only way that you get that is by hiring a Johnny Cash tribute singer because they have those vocal qualities. It might not be the exact same tonal qualities, but they have very similar qualities. I don't know. This is an interesting one. I kind of hope selfishly that Coke does not settle and that we do have some law in motion on this issue so that we can get a little bit more guidance.
Yeah, it would be very valuable to see how a court would treat the Elvis Act, given that, its recency. There might be some really good, interesting law that comes out of this.
No, I agree. I agree. Well, Richard, thanks again for joining me. Always great to have your insights. And thank you, our listeners, for joining us on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. So leave us a comment or review and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey, and I'll see you next time on the briefing.